all. Welcome to Preparing Clients for Deposition, recommendations from both sides of the table. I am Netta Thagathi, Vice Chair of BHBA's litigation section. I am delighted to introduce our speakers, Alexis Gamliel, Susan Gutierrez, and Mithili Sivaraja. Mithili Sivaraja is Senior Counsel at Tech Law, Employment and Civil Rights, where she represents employees in cases involving discrimination, harassment, retaliation, whistleblower claims, defamation, wage and hour violations, and wrongful termination. With more than 17 years of experience exclusively on the plaintiff side, Mithili has devoted her entire legal career to advocating for workers' rights and advancing social justice in the workplace. Thank you, Mithili, for being here with us today. Alexis Gamliel is the founder and principal trial attorney of Gamliel Law, an elite litigation firm focusing on employment matters as well as personal injury and wrongful death cases. She is equipped with deep litigation experience. She dedicates her craft to the fight for justice for California consumers and employees. In her employment practice, Alexis handles a diverse array of discrimination, harassment, retaliation, and wrongful termination matters. She is currently serving as the financial secretary for CAOC and will be the treasurer for the upcoming 2026 year. And thank you, Alexis, for joining. And last but not least, Susan Gutierrez is a partner in the litigation department and co-head of the firm's mass tort and product liability group. As a commercial litigator and trial attorney, Susan specializes in high-stakes matters and complex disputes across industry. She has tried multiple high-profile cases to verdict in state and federal courts throughout the country. Susan also has significant experience coordinating and managing large, complex action from the pleading stage through discovery and trial, including cross-jurisdictional matters involving multiple parties, counsel, and legal. And thank you, Susan, for joining us. And now let's get started.
Thank you so much. I'll be kicking it off, and nice to see everybody, and hope this is a productive session talking about depositions. I'll principally be talking about depositions from the defense side, though I think many of the rules are applicable regardless of which side of the aisle you are on. So this is sort of a roadmap for where I'll be speaking about looking at deposition basics, sort of the purpose and matters, what governs depositions, going to setting the scene. This is where we'll talk about some do's and don'ts and tips and tricks, if you want to call it that, with respect to preparation. Then moving into what I call safe harbors, which are themes that you want your witness to elicit during the deposition, and also that helps provide comfort for witnesses when they're particularly facing difficult cross-examination in a deposition. Next is reviewing of documents. There are different schools of thought with respect to preparing witnesses with documents or without that we'll talk about. And then finally, something that our practice group refers to as the memory spectrum, which is, as you'll see there, the I don't recall, because the I don't recall testimony, when given in especially seriatim fashion, is devastating or can be devastating to a defense side deposition. So starting with depositions, the purpose and why it matters. Depositions are really where stories harden or crystallize into evidence. In California civil cases, depositions are often where you get your first real look at how witnesses hold up under questioning. So today we'll walk through how to prepare both legally and psychologically so that you and the witness are ready when the record button starts. Depositions are governed by California Code of Procedure, sections 2025.10 to 620. And as I just mentioned, they are what creates the record that shapes potential settlement and trial. It's important to know that no matter where the goalposts are at the end of the day, depositions are going to help get you there or impede your ability to get there in the most practical sense. Many cases do not ultimately make it all the way to trial and to a verdict. 99% of cases, don't quote me on that exact statistics, but the vast majority of cases settle before trial. And oftentimes the deposition record plays a key part in effectuating the settlement. The importance of preparation really can't be overstated. It creates potential for lasting damage in transcript form or a potential sword to be used going forward to create your record. It can be used for impeachment at trial, can be used for creating your summary judgment record, and again, for shaping potential settlement. The ultimate goal, what you keep in mind in preparing witnesses, is teaching how to tell the truth, which is the basic rule of depositions, always tell the truth, but to do so in a manner that is calm, precise, and from the defense side, usually something brief. You really don't want witnesses going off on long ramblings or tangents that will expose them to further questioning. All right, so setting the scene, preparation and tricks. What I usually do is start with a brief case overview and highlights of case themes. What is this case about? Witnesses sometimes are brought in their own unique capacity, and they need to get somewhat of a bigger picture in order to understand where they fit within the case. So I like to start with what this case is about, what brings us here today, as well as some of the defensive themes that we're bringing across to bring the witness into the fold a bit more, as that helps testimony during deposition. That starts with also explaining where the witness fits into the case. So you are the ultimate decision maker on a particular dispute. Therefore, your testimony is going to be really key in establishing what went on with the deal, what were the negotiations, etc. Or perhaps it's a lower level employee. You were not the key decision maker. You don't need to carry that particular water, but you do need to understand and be able to explain in a calm and reasonable and abbreviated manner what it is that you do, where your knowledge is, where your knowledge isn't, in a way that doesn't sound like you're making excuses. So really pinpointing the witness to where they fit within the case and where they don't, because witnesses will have certain water to carry, but it's usually not the entire case. And so really giving them comfort as to where they fit into the puzzle helps set the scene. I then transition into talking about logistics. Many times witnesses that I've encountered have not been deposed before or have not been deposed for a long time. And so to settle their nerves, I talk about some of the easy things, which are the logistics. Where will the deposition be? How long is it expected to be? Is it by Zoom? Is it in person? And then further elaboration on what those look like. Who is expected to be there? Essentially try to create a visual in the witness's mind about what to expect when the lights go on. That transition into substance, which is where we'll talk about what are the goals of the other side here. The goal may be to establish that you as the ultimate decision maker did not take into account XYZ reasons in rendering your decision, or that you did take into account something that is supposedly nefarious or unreasonable. So understanding where the other side is going to try to come from is part of the preparation. Of course, our goals and our tactics. One note here that our practice group does that is a bit unusual in comparison to what I've seen many depositions do is our team will often use direct examination after the questioning is concluded. And the reason for that is that many cases that I do in complex commercial litigation last years and years and years. Witnesses may no longer be at the company. I've had witnesses pass away. Memories fade over time. And as you pass the deposition and gear towards trial 3-5 years down the line, you never know what's going to happen with a witness, either in their entirety or with their memory. And so it is helpful to have a brief, not a full-blown direct examination, but a brief 15 to 20 minute in the can direct examination that helps solidify your witness's story, even within a deposition being taken by the other side. We go over ground rules. These are many that all of us have had experience with, but they bear repeating. Listening carefully, underscoring that this is not a conversation. And it's amazing how difficult this is. Easier said than done, because many times witnesses get stuck into thinking, oh, this is easy. I can answer without taking a beat. No, the next guideline is always take a beat, no matter how simple the question. I say this even in response to, what is your name and current job title? You build muscle memory by allowing yourself a moment to just take a breath. Of course, it allows the attorney the opportunity to object, and it's just building that muscle memory by taking a moment. The other is asking for clarification. Some witnesses think that they should understand what's being asked and that there's something embarrassing if they need to ask for clarification. But I always underscore, if you don't understand something or you need something repeated, do so, because this record is being created and it's going to be evidence in this case. So anytime you don't understand a question or you don't understand a word, something seems off about the question, we can't proceed without your answer. So there's no harm in asking, I'm stuck on the word, I'm stuck on the word X. Can you explain to me what you mean? Or I'm really not following the question, or I lost track. That seems like it's two questions. There's a number of different ways to ask for clarification. Importantly, answering only the question asked. Again, this is to the point that this is not a conversation. This can be incredibly difficult for first-time witnesses, but it involves a lot of training with mock cross-examination. We do mock examinations of all the witnesses before they're in deposition. Remembering your safe harbors. This is something we'll talk about in a little bit. A safe harbor is a theme or a go-to that can be used in response to pretty much any question. The idea is to train the witness to hear the question, to understand the general topic that's being asked about. And if they falter in their memory, or they get nervous, or they're not sure what to say, they have sort of a go-to series of answers that can be used as safe harbors. The last ground rule that I always make sure to go over is the no Jekyll and Hyde personalities. One thing jurors hate, and whether they're watching a deposition by video or watching it in the courtroom, is when a witness appears one way when being asked questions by their lawyer. They answer just concisely, yes, no, versus when they're under cross-examination and they provide long-winded answers, or they're combative, or their personality just gets more aggressive. And so it doesn't matter at that point the substance of what they're saying, because jurors are also assessing the overall credibility of the witness. So we really try to emphasize the importance of being neutral and uniform in giving answers across the board. Okay, so talking about safe harbors, what are they? Safe harbors are an easy-to-remember tagline or theme that can be used throughout the deposition. A safe harbor is meant to be very short. It's not supposed to be a paragraph long. It's not supposed to be highly argumentative. They're usually single phrases or one sentence, things that can be used in a pinch or in response to particularly aggressive lines of questioning. Their purpose is to reinforce greater case themes. Some examples are, with respect to a negotiation, we made the decision for 3 reasons, A, B, and C. We made that decision for 3 reasons, and repeating that over and over again. Or there was no culture of collusion, there was a culture of compliance. I do a lot of products liability cases that involve pharmaceutical drugs, and so drug X was safe and effective for its intended use. Another one is, at X company, we're about science, not speculation. Those are just a few examples of safe harbors that we've used in prior cases that really underscore themes, and they can be responsive to many questions. That's the important part too. They shouldn't be complete non sequiturs. They have to make sense within the question, and that can be used across different question types. When are they used? They're used when the witness hears certain buzzwords or topics. So in some of my examples, whether the drug was dangerous, well, that's a cue for, no, the drug was safe and effective. Or for the decision maker, what were the reasons that you ultimately decided to go forward with the deal? There were 3 reasons that we went forward with the deal, being there at the ready. Or implications of collusive conduct. No, there was no, whatever you want to call it, culture of collusion. There was a culture, rather, of compliance. They're useful when the witness freezes or loses confidence, as can happen under, extensive examination or over the passage of time. And then there's, of course, if the question clearly calls for it. In the example of, what were the reasons you made decision X? That's an easy one to say. There were 3 reasons. And you really give the witness that as homework. We say, when you're just driving to work, when you're in the shower, practice these out loud. Actually practice them to yourself and get comfortable with them. It's not enough just to know the safe harbors, but to actually practice them throughout your day. Why are they useful? How can safe harbors be used? The principal reason is to give the witnesses confidence. In addition to telling the truth, the ability to go into a deposition feeling comfortable and confident is paramount. And having a safety blanket or a safe harbor really aids in that effort. The other benefit is that it helps insert case themes into substantive answers. So later, when, let's say, a jury is hearing the deposition testimony, let's just stick with deposition testimony, they're hearing themes that they may have heard referenced in opening statement and that they'll hear again in closing argument. This creates the impression that this is a uniform, consistent theme rather than something that was just concocted by the lawyers, but rather that it's something that the witnesses have adopted as the evidence bears out. Similarly, or another benefit is that safe harbors can cut off certain lines of questioning. I've seen where the witness consistently provides their safe harbor answer and the examiner eventually moves on. Not because it isn't responsive, but because the invocation of the safe harbor is detrimental to the other side in a manner that they would say, okay, just forget it. I'm going to move on with my questioning. The next is reviewing documents. And it says, yes, show the witness documents. So stepping back, one common method, and I've seen this time and time again in preparation, is not to show a witness documents. There's a belief that somehow for the witness to get to the deposition and to say, in response to the inevitable question, did you prepare for the deposition? Yes. Did you review documents? There's this misconception that you want the witness to say no to that, as if there's something sacrosanct in being able to say no. Our approach is to do the opposite, is to show the witness, is depending on what type of witness it is. For instance, a 30B6, you have an obligation to educate the witness. But even if it's not a 30B6 witness, showing the witness's documents is not taboo. It helps the witness get confident in what their answers are, and also to remember things. There's nothing wrong in having one's memory refreshed by showing documents. It makes the deposition seem much, much more credible and your witness seem much more prepared and confident. You really don't want the witness seeing documents for the first time in the deposition, feeling blindsided, because that takes away from their confidence and makes them think, oh, what's coming next? What haven't I seen before? And you might be thinking, well, that's fine. I just talk to them about the documents. I'll be physically holding the document and say, I want you to assume that there's an email that says XYZ. That's one way to go about it, but there's something that's really beneficial I've seen in preparing many witnesses for deposition, where they actually get to lay eyes on their own words or the words of others on emails that they've received. It helps paint a picture in a way that simply being told it orally doesn't convey. Why the different approach? In a difference to building confidence, it creates a much better usable record. When they provide substantive answers, that shows that the witness knows what they're talking about and believes in what they're saying. So when they get to trial, it's not as if they have some sort of amnesia or they're saying, oh, well, that's what the document says. Having a witness say, I see the words on the page over and over is not effective. It erodes credibility. It also helps prevent witness amnesia. The witness amnesia is, we've all seen witnesses say, I don't recall, I don't specifically recall, I don't recall. First of all, no person really talks like that in normal life. We say, I don't remember. So that's a nuance that I always tell witnesses. Talk like you were to a normal human being. If you don't remember something, say you don't remember. But I've also had the situation where another firm handled the deposition aspect before we were brought into the case, and we're stuck with the record as it existed. And it's a deposition that by the time of trial gets spliced up into 30 minutes of a witness saying, I don't recall, I don't recall, I don't recall. It's devastating. And it can be prevented by showing the witness documents and actually engaging in a substantive discussion about what they say, what they mean. Those conversations are protected by privilege. There's really no downside into saying, essentially, yes, this witness prepared. You all know the witness prepared. There's no harm in saying, yes, I saw the documents. In order for the documents that you show the witness to be producible or to be told about, there has to be a very series of specific lines of questioning before you get to that stage. You can't just simply ask in a vacuum, tell me all the documents you looked at in preparation. You can invoke work product protection for that. What you have to do is the other side has to show a document and establish whether it was one that in preparation was used specifically to refresh recollection. It may be that your witness doesn't need their memory refreshed. They may see a document and say, oh yeah, I remember this. And they didn't need the document to refresh their recollection, in which case there's no disclosure necessary. But even if there is, our team's approach overall is, so what? Embrace the fact that the witness looked at documents, embrace the fact that there are documents, because it allows for an overall better evidentiary record. Finally, and I apologize for breezing through these, is the memory spectrum, and I can spend a bit of time on this. This is the I don't recall. You might notice that I'm on a bit of a kick with this, because so many times throughout the years, I have seen deponents say, I don't recall, over and over and over again. And from the defensive side, there seems to be this mentality that that's somehow winning the deposition. if you can get out there with as little substantive answers as possible. Oh, great, their summary judgment record didn't get any better. Hurrah. But you've got to think beyond summary judgment. You've got to think to potential trial. And even with summary judgment in mind, you can manage the memory spectrum in a way that doesn't create a triable issue of fact. So we talk about explaining where you are on the spectrum. On one end of the spectrum is something you literally know nothing about, or you are truly a black box. I know nothing, period. I couldn't tell you where I was. I couldn't tell you if I had ever been there. I was essentially blackout at that point. That's one end of the spectrum. The other end of the spectrum is where the witness has an absolutely crystal clear, perfect memory. I remember where I was. I remember exactly what I said. It is as if I were there just moments ago. 100% crystal clear memory. Memory really doesn't work that way. Usually, witnesses fall somewhere in the middle of the spectrum. They have a general recollection of what happened. And what we say in those instances is, give where you are on the spectrum. This is where it's okay to provide a bit of color, a bit of detail. So I don't remember that specific meeting, but I know that when I attended meetings like this, the practice was to create minutes and then leave it at that. You've created a much more credible answer than I don't recall. When was the meeting? I don't recall. What was talked about? I don't recall. Who was there? I don't recall. Were there minutes prepared? I don't recall. Versus, when was the meeting? I really don't remember. I want to say it was around Thanksgiving, but I couldn't tell you for certain. What I do know is that those were the types of meetings I would usually attend. I just can't remember if I was at this one specifically. That's a much more credible, believable answer than your seriatim I don't recall answers. Another way of an explanation for something on the memory spectrum is where you really lack memory. You can say, I really don't remember. I'm struggling to remember where I was. I do believe that there were minutes prepared, but I really couldn't tell you for certain. That's essentially saying I don't remember, but it's saying it in a way that provides more color and more depth to your answer. Again, thinking about a way that the jury is going to intake this sort of answer and judging your witness's credibility. So I think with that, I may be done, and I'm happy to jump in and chime in with others as we go along the presentation, and happy to field any Q&A as they come up.
Thank you so much, Susan. I believe I am next. I will give it a moment for my PowerPoint presentation to pop up on the screen. But that was a very eye-opening window into the defense perspective on preparing your clients for deposition. So thanks so much for that. I'm just going to go ahead and share my screen here. Let's see. Okay. All right, so my name's Alexis Gamliel. Based on the introduction, I hope that you all understand I am a plaintiff's attorney. I represent individuals in personal injury and employment actions, specifically within the employment arena, where I represent women in sexual harassment and gender discrimination cases, as well as a variety of individuals in whistleblower matters and all sorts of other employment cases, I believe similar to Maithili, whom we'll hear from soon. So I'm here to provide the plaintiff's perspective. I think, like Susan, I will reiterate that much of this will translate across both sides of the aisle. So hopefully, no matter which side you represent, you'll be able to take away some actionable insight from the presentation today. And I also want to say thank you to the Beverly Hills Bar Association for having me, and we'll just dive right in. So there are really two components, the way I see it, to preparing for a plaintiff's deposition in a case like this. Typically, we'll talk about preparing our clients, but we also need to talk about preparing ourselves. So when it comes to this first component of client preparation, I'm going to be talking about the different tools, insight, and inspiration that you can equip your clients with, specifically as it relates to the tools, similar to what Susan was talking about with the safe harbors, giving actionable things that your clients can rely on. Insight as it relates to the process to give clients that comfort for the framework so they know what to expect. And finally, inspiration to make sure that they have the confidence that they need to sustain several hours of deposition. In the employment context, we don't have that 7-hour time limit that exists in the personal injury space. So just setting the stage and setting expectations as far as the timeline, who will be there, and all those kinds of things that will give your client some confidence going forward. So for those first-time deponents, your preparation is going to look a little different. We'll go very basic and talk about what the framework is, who will be there, who's going to be typing down the questions and answers, and all of the colloquy that is stated in the deposition. And then the ramp up, which is getting into the more nuanced case-specific facts and topics that will be addressed during the deposition. So when it comes to preparing clients for deposition, and really any case that I'm working on, I focus on having a trial-ready approach. And that includes looking to the finish line of where this case is going to end up. So as you mentioned, Susan, we want to make sure that we are not only focused on the deposition testimony, for example, for things like a motion for summary judgment, or in my case, opposing a motion for summary judgment in many instances, but also on what that finish line looks like and how is this going to play out to a jury? How are we going to assemble all of the evidence that we need to defeat motions that come up, to proactively file motions as needed, and things like that. So from that lens, when I'm preparing clients for deposition, I first start with the very basics when it comes to especially preparing a plaintiff for deposition. These are not individuals who have sat for deposition before in most instances. So we're not talking about persons most qualified to testify on certain matters, or company officers who may sit for deposition across a wide variety of topics or cases. But in most of my cases, my plaintiffs and my clients are addressing this for the first time. They are completely unaware in most instances of the format, other than what they've seen maybe in Suits on TV or in movies and things like that. So we really have to go very bare bones. So I explained to them a deposition is an under oath question and answer session that holds the same force and effect as if you were to testify in a court of law. And I impress upon them the importance of all of that. But at the same time, giving them that comfort of, while it's not a conversation, it is of critical importance to your case. And in most instances, this is the one and only time that the defense attorneys or the defense attorney will have the opportunity to talk to you about your experience and the facts that form the basis of the case. So along those lines, I explained the format, the who, what, where, when, and why. So when it comes to the who, going down to this third bullet point here, parties and counsel are those individuals who are permitted to be at the deposition. And as I mentioned at the beginning of this, in many instances, I handle sexual harassment cases. So I have to have very difficult and candid, frank conversations with my clients about it may be that the person who engaged in this sexually harassing conduct will be at the deposition if they're a party in the case. So that requires a very delicate, emotionally charged conversation oftentimes. And there are instances where you can file a motion for a protective order to exclude certain individuals from depositions. The Code of Civil Procedure citation is there for you. We can talk a little bit. There could be a whole entire session, MCLE session on that area of law, but again, going back to the basics and priming the client for here's what to expect. It gives you that confidence when you walk in the room and you know who will be there, what the process is going to be like. And this might seem elementary, but truly on the plaintiff side, it's very important to give your clients that confidence so that they can focus on what the case is really about, not about the feeling of uncertainty as far as the process goes. So when it comes to the what, giving your client a rough outline of what you expect the substance to be in the deposition. For example, if it's in a personal injury case, we're going to talk about the incident itself, your injuries and treatment, and then your general damages, just to give a high level understanding. And then also addressing that at the beginning, the defense attorney will likely go through what we call the admonitions. You'll be hearing the ground rules, much of which we'll go over in the preparation session. And finally, as it goes to the mindset of your client, we want to reassure our clients that we will be there with them every step of the way. Even though this is their first time, this is by no means our first time. We've been here, we've done this many, many times. And so giving your client that reassurance really does help. So going through the mechanics, and forgive me, this little picture here is just to paint the picture that really we do want to be trial ready. This is a photograph of me from my very first trial. I always go back to these memories because it's very important to understand where we're ending and how the deposition testimony plays into that full picture of the case. So when it comes to the mechanics, as we all know, many depositions are still being done via Zoom or through other remote proceedings. Many depositions now, I'm finding I personally prefer an in-person deposition, especially when I'm taking a deposition, because I can ascertain many more of the nonverbal cues that these witnesses have. But no matter whether your deposition is going forward in person or through a remote platform, you want to do your preparation meeting, I believe, in whatever format the deposition will be. So that way you can prepare your client, especially when it comes to, making sure that that your client is in a private place, that they're going to feel comfortable to be candid. Oftentimes we're probing into delicate matters, especially in the sexual harassment arena and in other case types as well. You want to make sure you have that privacy, and also make sure that your client is in a space where their presentation is not going to be compromised. And we'll get into that in a moment. But no matter how the deposition will be proceeding, do your prep in the same way so that you can plan ahead. The process. So I also explained to my client that they will raise their right hand. They will swear to tell the truth. I will have, as your attorney, an opportunity to object to certain questions. We'll want to explain to them the mechanics of that. That doesn't mean you don't have to answer the question. You do have to answer unless I instruct you not to answer. Sometimes clients, especially those who are doing this for the first time, they don't always know to anticipate those objections. And more often than not, you want to let your client's testimony flow very seamlessly. So I do my best to not get in the way of my client. Of course, in order to preserve those objections for trial, you want to lodge those objections in a judicious manner. But again, having that trial ready mindset.
If I could just interject quickly from the defense side, one of the things, Alexis, that you said reminded me of, we also prepare when we're doing the mock cross-examination, we also do insert having an attorney practice objections.
Mm-hmm.
And we will go through with the witness what objections are cues for. So if the witness seems like they're relatively savvy and can follow along, we will say, for instance, if I object and say asked and answered, that's a cue that you've pretty much just answered the question already and they don't like the answer that they're being given. Or objection vague. You do have to keep your objection succinct, but if you're saying something like objection vague, that's a cue that, to me as the lawyer, there's something hinky with the question. And
yeah, I think that's a wonderful point. And on that note, especially in employment cases, when we're not talking about a moment in time, we're talking about conduct across years. There can often be instances where a question is vague as to time. I find that is often one of the ones that comes up most frequently. So I do recommend that my clients, first of all, as you mentioned before, we want to make sure that they understand any question that they're being asked and to ask for clarification as needed. That especially is true when it comes to the time frame of a question. We want to make sure that our clients are equipped with the tools that they need to speak up for themselves. And if they hear a question and they're not sure about which time frame is being addressed, that they should speak up and ask for that point of clarification.
yeah, absolutely.
Yeah. Okay. Another thing that I think is important that we explain to our clients is when we are on the record, when we are off the record, making sure that they have an understanding that the court reporter who's there is taking down everything that anybody says, and that anything that occurs on the record will go into that transcript. And that they're being videotaped more often than not. A plaintiff's deposition in a case, whether it's a personal injury case or an employment case, is videotaped. Sometimes they're not. When I'm taking depositions, I always videotape them. Again, having that trial ready mindset is very important to me. And to zoom out to what is going to happen with all of this, I advise my clients afterwards, you're going to receive the transcript in the format of a booklet, whether, in the old days before, at least the last several years, the clients would receive a hard copy booklet. Now, of course, we get those electronically, and it's really easy to mark as read, or sign and just kind of let things go. But we need to make sure that our clients understand the importance and the gravity of their deposition testimony being boiled down into a booklet, and that they have the opportunity to read, review, and sign that transcript. And when they do sign, it holds the same force and effect as if they were to testify in a court of law, that the testimony is under penalty of perjury. Of course, as we often hear in the admonitions, and our clients do have the right to make changes or corrections afterwards. But the important thing is that those changes or corrections can be commented upon at trial. So we want to make sure that we get that testimony right the first time. So emphasizing to our clients the importance of that, even though they will be advised more likely than not at the beginning of their deposition by the attorney on the other side that they have that ability to make those changes, that we want to make sure that the testimony as it's given on the day that it's given is accurate. And that if they're not sure of something, that they give themselves some wiggle room in the words that they use. So when it comes to preparing clients for deposition, there really are, in my view, two rules at the top of the food chain here. Number one, always tell the truth. There are a lot of things as lawyers that we can fix and that we can massage later on if we need to, but you cannot fix a lie. So we need to make sure that they understand the importance of this. And the second thing is to answer only the question that's being asked. First of all, it's important because we want to be very focused with the answer. But second of all, I think it really helps for a more efficient deposition. And I think the attorney defending the deposition appreciates it, but also the attorney on the other side, because we're staying responsive and staying on top of the answer. The other key points that I like to emphasize with my clients are that there's really a twofold purpose to a deposition. It's both what you say and how you say it. So it's a combination of substance and presentation. What that means is not only are we focusing on getting out the facts that are critical in the case related to the causes of action at issue, but and also our client's damages, but in addition to that, it's how the client relays that message. And like Susan, you said, it's about credibility, right? And you have to have that mindset going in. Now, these can be somewhat delicate conversations, again, that we have with our clients. You want to show up as if you're going to a job interview. You also want to be comfortable and feel like yourself and be yourself in that deposition. But with the understanding that eventually later on, these deposition clips could be used in, let's say, mediation. They could be used at trial and a variety of other things. So your audience is not just the attorney on the other side. It's also perhaps the insurance carrier, when that deposition transcript and video gets shared. It's also the jurors eventually. So you have to prepare not only for the audience that you're facing that day, but also down the line. In order to not put too much pressure on our clients and make sure that, but at the same time having that concept in mind of who will see it, we just want to advise our clients, show up, put your best foot forward, be comfortable, be yourself. At the same time, you want to have a polished presence and appearance. And it's not only about attire, it's about being articulate, being trustworthy in your message, and making sure to answer the question. And if you're nervous, we need to work through that and figure out how to calm those nerves. And sometimes the preparation can be a much longer meeting. Sometimes it can be many meetings broken up into hour-long increments or half-hour-long increments. It really does depend on your client and how your client focuses best. And really what weighs into this decision as to how to break up the preparation, I think, is the trauma and the emotional weight, and it depends in large part upon the case type. So you need to get to know your client well in advance of the deposition. If the first time that you're really sitting down and getting to know your client is the deposition prep meeting, then you're already behind. You have to get to know your client and do it, periodically. Set yourself reminders to just have meetings to check in. You don't always have to have a specific purpose in mind in terms of like getting information or meeting in advance of a hearing or something like that. You can do it for no apparent reason, and there will always be a reason that unveils itself. And part of that is bonding with your client. On the plaintiff side, it's really important that we have that unbreakable bond, because we are going through the fire together. And so that's just a little bit about the purpose. And Susan, I saw you unmute, so feel
Yeah,
free
I
to.
did. I was
Yes.
here with reference to dressing on the defensive side. It's something that is also very important, and especially when you are dealing with an executive, a high level executive, for instance. And if the deposition is by Zoom, as most are, at least in my practice currently, thinking of things like the background of the Zoom is incredibly important. So what is, jurors are looking at everything. So for an executive, you don't want to have something that looks like they're in a high-rise building of some fancy schmancy office. So we really try to watch, little accoutrement that may be in the background. Whether are there awards, are there family photos, what is in the background there, as well as what they're dressed like. Many people have an aversion to high-level company executives, and so in that instance, we often suggest to the witness that if it's a man or somebody that wears suits, wear a jacket, wear a button up, but don't wear a tie. Don't become excessively formal to the point that you are distancing yourself from the average juror. You're showing a respect in the same way that you would appear to a courtroom, but don't overdress in a way that emphasizes, what may be a significant financial divide between you and the people seeing this video.
It's a very good point. Along those lines, in addition to attire, presentation is also demeanor, right? And so we want our clients to be forthright. They have nothing to hide. And so the demeanor, we have to also prepare them so that they're comfortable asking or answering questions and not having that nervous energy. Responsiveness we've discussed. Also, it's okay to ask for clarification. And of course, we want to make sure that our clients have audible responses. We don't want to trip them up in the middle of the deposition where the defense lawyer is asking them, is that a yes? And all of those things are very easily avoidable. And so we're going to take a step back and rewind and talk about our preparation before we prep our clients. So referring to this behind the scenes of the client prep is the attorney prep. So along the lines of reviewing documents in employment cases and personal injury cases, you have your discovery responses, medical records as applicable. For example, that would certainly apply in personal injury cases, but equally in disability discrimination cases or failure to reasonably accommodate cases. Incident reports, investigation reports, witness statements, policies and procedures, payroll records, personnel file. There's a wealth of documentary evidence that can be relevant in cases like this. So you have to look at the universe of the documents that exists in your particular case, and don't only look at the documents you've produced on behalf of your client as the plaintiff, but also on the other side, the documents that the defense has produced, because we want to anticipate the defense's review, what the key contentions are in the matter. And then, of course, the complaint. In a case like those that I handle, in many employment cases, the attorneys will go through the complaint because they want to make sure that this is not just the attorney talking in a pleading, that it matches and mirrors what the plaintiff's experience is. And of course, we want to make sure that the plaintiff is fresh on that information. The timeline Many times this will not come from documents produced in the case. That would be something that you as the attorney would prepare. And sometimes, as I mentioned at the beginning of this, there are cases that span years of conduct. So you want to make sure that you have those key dates locked in, again, to give your client the confidence that they know what happened when. They lived it, but it may have been several years ago that they lived the experience. So it's a good and helpful tool to create for your client and discuss. And that concludes my presentation, but happy to answer any questions at the end. And thank you for the opportunity to speak to you.
All right, I will have next tech up in just a moment. Thank you.
All right, so I'm Maipuli Savaraja, and I do employment, pretty much employment. Most of my cases are employment cases, some civil rights cases representing plaintiffs. So I'm gonna I'll wait for the slides, but I'll comment on some of the stuff while we wait, and I'm gonna rush through some of them since we're running behind. So essentially, hold on. Could you flip the slides on rotating for me? Next. Okay. So we're gonna go past this because I think everyone's talked about this. Essentially, credibility is one of the most important things. So, and I think for prep, you really do want to prepare your witness so that they have the confidence and clarity, not just on the liability side, but also on the damages. Obviously depends on the witness, but for plaintiffs, they need to understand it's not just about the chronology and the timeline and the theme, but also how to prove up their damages. Next slide. It's working. Okay. This is just roadmap of what I had planned. We'll go over the planning, admonition, some difficult scenarios, technical issues, mock Q&A, and some takeaways. So for me, I look at it in 3 phases. I think prep for deposition starts from the moment a client walks in. For me, so I'm thinking about timeline, key documents, and the written discovery. So the moment written discovery documents start coming in, I start marking up. These are key documents, and I don't wait for the actual notice to come in. We want to get the clients really prepped so that, because a lot of times there is a lot to cover, and by the time the deposition notice comes in, it's too late to give the time to really prepare somebody and then assure them that they're okay, meaning someone who's never been in a deposition, they're going to have all the nerves and emotional issues, as Alexis talked about earlier. So chronology is one of the key things I drive home to plaintiffs, is need to know the facts, because as an Susan referenced, the I don't recall response is not going to cut it for plaintiffs, right? If you cut yourself out as a do not recall witness on a key point in your chronology, you're taking yourself out as a witness, right? So it is critical that, especially for the material events in the chronology, that they know that sacrosanct, because if you say, I don't remember, and a defense witness comes in and knows a different version of the fact, that testimony is going to stick. Damages is another item that I think needs to be worked on from the get-go. So you can't wait for the deposition notice to come in to work on damages. There are some clients, harassment cases, disability cases, it's very tenuous for them to even talk about it. So you're gonna need to break it up. And it's not going to be 1 session, 2 sessions, 3 sessions. It might be multiple sessions, starting with written discovery responses. So when the form logs, all those damages questions come up, I spend a lot of time with the clients to say, okay, now remember, this is going to come up again in your deposition. So let's make sure, not just like saying sleeplessness, headache, whatever. actual have descriptions of what that means, how you've gotten treatment. All of that needs to be specific. Okay, and then some of the other things, depot notice, chronology, key documents, and then if they've had any prior or concurrent lawsuits, obviously need to cover that because that's going to come up. And then the next thing, which I've had some clients talk about, how my questionings on the mock Q&As are harder than defense counsel's. And I tell folks that, hey, I'm going to make it hard because I'm a hard grader. So I do both things, friendly defense counsel approach to questioning and then aggressive defense counsel approach to questioning. So you play both parts to see and I'll tell you that I find the most dangerous are the friendly opposing counsel witnesses because you build the rapport and then soon enough you have clients, speaking, opening the Pandora's box, answering questions way beyond the scope of the question that's answered. So I believe that mock questioning and kind of managing the emotions, the anxiety, all of that is really important. And the actual doing, like the mock Q&A, doing multiple sessions with different approaches, different questions. So sometimes I just say damages. We're just going to do damages. We're not going to talk about anything else except damages. Sometimes we're just going to talk about just this one aspect, performance deficiencies. We're not going to talk about anything else, just that. Just to sort of get them into like, here are the phases of the questioning that might happen. And then I also tell folks that even during the deposition, I'm a hard grader because as Susan and Alexis have echoed, it is really important to get the transcript accurate as possible while you're doing the deposition. I have only had a handful of clients in all my years who have actually corrected a transcript because I make sure, and I'm a hard grader, if they miss something or speak out of turn, you go back and correct it right on the record during the tenure of the deposition. Okay. Let's go to the next slide. Okay. I'm not going to go over these. I think these are already talked about, but I think one of the most important things, like with all the admonitions, the important thing is answer the question in the shortest and most accurate way. I mean, most accurate and shortest possible answer. If you forget anything else, just remember that because your credibility is the most important thing. And then these are all kind of secondary, like understand the questions. If you don't understand, make sure you understand. It's okay to ask the question to be rephrased and don't feel like you're stupid for asking that. Because I know a lot of clients who may not be as educated have some psychological barriers too, right? They might not be speaking the language. If you have translators, there's like another barrier, right? You have to wait for the translation to happen before the next thing happens. So talking over each other, that is, I mean, I think goes without saying, but I have had depositions when the court reporter has had to like break it up and then I've had to have spats with the court reporter, but I always say like, hey, just pause and like take a deep breath. And if I find that the client is too anxious and it's just kind of not going well, I take them out. I'm like, okay, we need to take a break. Let's go for a walk. There's something awry here. Oh, let's see. Handling difficult. Okay. Emotional topics and crying. This happens a lot in many of our cases, sexual harassment, disability cases. And I have encountered many clients, especially those who have had disabilities, who want to push on, right? Like they don't want to take a break. So it's not one way or another, like, hey, keep going or not keep going. I check in with them beforehand. I will say, shoehorn into this is stamina. I have had some clients, especially after like the lunch break, like, I want to finish this. I don't want to come back for another day. I want to finish this. I had a client fall asleep on the record. So because she didn't want to take another day off, and she literally fell asleep during questioning. It was like, like an hour or two after, and it was live deposition. So after that, even if a client says like, I'm gonna push through, if I see like they're kind of phasing out, and I've taken them out and said, hey, this is not a marathon, right? Like, if you're tired and you can't answer the question, hey, am I able to, and what's the question? Am I able to proceed with the deposition, prepared to provide your best testimony? If you can't say yes unequivocally, then you can proceed. Privileged, embarrassing questions. We need to address those before we get in there for sure. So I call these skeletons in the closet. So even when a new client comes in and I'm about to take the case, I talk about this. If there are skeletons in your closet, something from the past, like we have clients, especially in abuse, sexual harassment cases, past abuse, where they don't want to talk about family members, anything like that. We need to know that as soon as possible, because you don't want that coming up in depositions, or we need to know how to address them. And that goes to the the instruction not to answer. So we go over if there are pieces that we are not going to go into to address it, maybe move for a protective order so you're not in that position. Okay, then we have multiple defendant issues. You just need to, when there are multiple defendants and there are multiple defendants questioning at the same time, I make sure that they allocate time. So especially if you're in federal court and you're in the 7-hour limit, well, you're not in the 7-hour limit if you have multiple folks, but you do want to make sure that the time is allocated, because the client's going to get tired. Okay. I'm not going to go through these. The technical readiness is something important to go through with your client, because if you're not savvy with it, you're going to have issues with that. Same thing, managing exhibits and documents. I think Susan talked about it. Make sure you go through it beforehand. And I also tell all witnesses, even if you've seen it, if you see it again in deposition, don't say you've seen it without reading it. Make sure you actually read it and take the time to do it. Don't worry about taking up time or taking too much time, anything like that. Okay, next slide. Yeah, I'm not going to go over this because this is small, but obviously objecting to the notice if there are issues beforehand, especially if there are notice for production of records, right? So you don't want to wait till the actual deposition to make the objections. You want to do it before. And then protective orders. I've had to do this for location of deposition when my clients have moved away out of town, and the other side has wanted the deponent in person. So that's the only other thing I would say about this. And then Alexis talked about this. The way I've handled depositions where the defendant is a party who was also the harasser, for instance, where the plaintiff really doesn't want the person there. I've addressed it as, when the question is asked, are you able to provide your best testimony today, to say, no, I'm not, because this person is here and they cause me emotional distress or whatever it is, and have addressed it that way. And then most of the time I address it before with defense counsel, so we don't need to deal with it when we're in the room. But if there isn't an agreement, then we address it that way at the deposition.
And if I could just chime in on this point too, another way to address this proactively is to reach out to your opposing counsel and have that candid conversation of who do you intend to have at the deposition. It will work on the right case, and you'll know the dynamics between the parties and counsel as well. But just another tool to have in your arsenal.
Yeah. Yeah. And then there's talked about this mock Q&A, and I do these pretty vigorously to test out which how the witness does, and then so that they feel assured. Sometimes they're more not assured, and then when they get to the depositions, like, oh, I'm glad I'm prepared because now this is a lot easier. And then so we debrief afterward. Yeah, and then the only other thing I would say is for post-deposition follow-up, I like to do all the housekeeping things right there and then as much as possible. So if we need to continue deposition, put it on the record. If there are any documents that still need to be produced, put it on the record so there isn't any sort of ambiguity. And I had a deposition go on for 2.5 years because of just documents not being produced. So it was one plaintiff deposition that went on and on, like we had 5 depositions. So try to nip it in the bud so that doesn't drag. All right, so I think those are most of what I had to say. Anything really just need to prepare folks early enough, and then all right, do we have questions? I think we have a lot of questions. Right?
Great. So we do have a couple questions in Q&A if you guys would like to address them. So, Susan, I believe this one's directed towards you. They're asking if you can revisit a concrete example of a safe harbor.
Sure. Safe harbors, the ones that I gave examples of are what I call them the 1, 2, 3. So 2 points is too few, 4 points is too many. So we stick with 3. Usually if you have something like a decision maker or a contract issue, you say something like, we made the decision, or I made the decision for 3 reasons. 1, 2, and 3. And repeating that over and over. You can have a more thematic based safe harbor. And an instance there was no culture of collusion. You can go further and have them be offensive too and say there was a culture of compliance. But combating that notion of culture of collusion, you build that into the witness's answer that underscores a theme that you're going to be proffering at trial.
Great. And then the next question is, I guess this could go to anybody. What guidance do you give to your clients on how to listen to your objections to glean how that might impact how they respond?
I think we responded to that somewhat earlier, but for instance, if the objection is asked and answered, I think I wrote in my notes, like misstates testimony, that's like a cue to you as the witness, hey, listen to the question, maybe it's been asked and answered, or it misstates your testimony. So, and I think, Susan, you referenced, it really depends on the savviness of the witness. Some folks can, others, you don't want to get into it because then that throws them off there.
I usually keep it pretty succinct with that. I think asked and answered in misstates testimony are ones that are easy for witnesses to remember. Calls for speculation is one where that's a cue. I'd say that's a cue that they're trying to get you to guess at something. Of course, they're entitled to an estimate, but you shouldn't be guessing flat out. So if you hear me say speculation, they're asking you potentially to guess at something. When you get a more deposition proficient witness, you can go into more nuances such as, vague and ambiguous, or even something as, convoluted as lacks foundation for a very savvy witness or a witness who's a lawyer, perhaps.
Yeah. Or calls for expert opinion would be a cue to the witness to not opine on their medical condition or something like that. But really, if they can still answer the question of what their understanding was as far as their diagnosis or what the issue is, then that would be a good course of action.
All right. The next question is, almost all of my clients need an interpreter. I'm thinking that at the mock depo, I start bringing in the translator because it always throws people. At the mock depos, their bosses or someone else at the company will translate, but it's not the same as a pro translator. My clients don't have a lot of money, and I try to keep depo costs on the lower side. What are your thoughts?
Yeah, I think trying to simulate the circumstances that they'll face in the deposition is the safest bet you can make, and to do that within whatever cost constraints you have.
And I would say that if you are not able to get a professional interpreter for cost reasons in the prep, you can simulate the time in which it will take by having, really practicing so that your informal interpreter is not allowing crosstalk, and really practicing, okay, when this person is speaking, do not say anything. When they finish speaking, listen, and, then is your time to answer. Really just practicing the fundamentals of having long periods where you're truly just listening before you say anything, and having that beat is another way to go.
Great. And then the next question, if a client wants to confer with you privately during a remote deposition, no question pending, how do you handle it? Do you go off the record and communicate via cell phone or WhatsApp?
I would, if the witness is communicating with me during deposition, that is somewhat of a problem.
Yeah.
You really can't be having that, but I would take it to say that I need to ask for a break at the soonest opportunity. You don't need to give an explanation for why you need the break, since in this scenario, there's no question pending. I really try to avoid having substantive conversations with witnesses while depositions are pending. Depending on the jurisdiction, they can be considered, once they're under oath until the examination is complete. You really shouldn't be having those types of conferences. But not many times, there are times where witnesses just feeling, I'm really getting a bit tired. What do I do here? And that is a perfectly appropriate conversation to have. And of course, if you need to consider if there's any privilege at issue. But for the most part, I do try to tell witnesses, once you're on, we're not going to be having substantive discussions about your testimony because you don't want to open any doors.
Yeah. And while opposing counsel is not permitted to delve into the substance of any attorney-client communications, they can ask questions around the factual circumstances of the communication. For example, if you took a break and it was a 30-minute break, the opposing counsel could ask your client, what did you do during that 30-minute break? And they would have to say, I spoke with my attorney. Then they wouldn't have to go into and wouldn't be required to go into what they discuss, certainly not, but it would, you just understand that exists, that's a risk as well.
I just want to chime in, not to polarize that too much, because I do think that it's important to get the record straight. So if you have to have conversations to clarify things, I do think that it's more important to correct the record while the deposition is going on versus correcting it with the transcript.
Of course. Yeah, I agree with that.
Great. And the next question is, when taking time off work to attend a deposition as a plaintiff, is it considered protective leave? Can an employer with a no-fault attendance point system require the employee to use their points or to have sufficient points?
I actually don't know the answer to that
I
question.
don't know either.
All right, moving on. Will you kindly elaborate on instructions not to answer, from your view, some examples?
Certainly the most, the clearest example is if something calls for privileged information. And that may seem obvious, but in the moment, the question may be a bit of a gray area as to whether privilege is implicated. And so in that circumstance, what I've done is say, I usually have real time with me, but if not, I can just be listening carefully and just say, just give me a moment before you answer. I'm reviewing the question or I'm thinking about the question. And it can feel a little bit awkward, but at this point, I'm not embarrassed by it. And I'll say, if that seems to infringe on the substance of our communication, or if you can answer that without disclosing the content of attorney-client information or advice that's been rendered or requested, you may do so. Typically, the witness is unable to do so, and then they'll stand by the instruction. Another one is if there's privacy at play. I've instructed on the basis of privacy. Many times the plaintiff's counsel will ask the witness, a random fact witness, what their residential address is. And I've instructed on that, and it tends to result in somebody asking me if I'll accept service of a trial subpoena for 1987 purposes, which is something that will have been discussed in advance and in the preparation so that, when that representation is made and the instruction is given, there's not a big kerfuffle about it.
All right, I believe that about wraps up Q&A. Thank you all so much for your time today. We truly appreciate you speaking on this topic to our members.
Thank you very much.